Yes, yes, yes.
So by the time they reach that bunch, it is taking some time. There is a practical difficulty. So it will appear. All of it will appear.
So I'm mentioning this matter, WPA 9595. There's a against an adjudication order we had filed on 28/4/25. Now the file was not there, and in the meantime they had issued recovery notice. We had emailed them that the matter is not in the list, but we have mentioned to the honorable court. I have been told, Lordship, that the file has come to the court now. Lordship has earlier allowed this to be given as urgent motion. Lordship, may kindly, if tomorrow, if your Lordships can take this matter, because they are. I have attached the email of the department also.
Tomorrow is the day for specially.
Lordship, in the list it is written also urgent matters. In your Lordship's printed list.
That's there.
That is why I am taking liberty for tomorrow, otherwise on Monday, Lordship. I have emailed to the department that kindly wait for one more week. Their recovery notice also I have attached, Lordships. And it is, I have served them.
So let it appear on Monday. What's the problem?
Lordship, Monday upgraded motion, Lordship, kindly.
Monday it urgent motion is given. Please give a notice to them.
It is there. Last page, Lordship, I attached the notice.
To give one more notice that it will be
appearing as a upgraded motion.
It may appear as a upgraded motion.
Lordship.
Any day,
Lordship.
tomorrow or Monday, so that they are ready.
Lordship, Lordship, these matters for inclusion, Lordships. There are several matters, Lordship. All the matters have notices.
All of them will appear. Only thing is that yesterday they had come.
Interim orders, those of you have not, I will again mention tomorrow because I was waiting free now because last week is there.
Yes.
Interim orders, I will again mention.
Interim orders, please mention. Those should come.
My lords, I am mentioning upon notice, my lords. Similar prayer, my lords. A recovery notice has been issued in October 2025, my lords. And
regular urgent motion. You have written your grounds of urgency.
Recovery notice.
Urgent Monday diye dein.
I'll serve a notice also.
I have your Lordships kind leave to mention this is a hearing matter, my lord. Under urgency, I have come before your Lordship, and I've mentioned previously also. My lord, the person after acquittal, honorable acquittal, this is the headmaster of the school. He has been demoted. This cannot be done, and his place another person has been deputed. I'm grateful, my lord. He will be retiring in 1 month. And there are two other matters, my lord. This honorable court, the coordinate bench has fixed a timeline. This is a lien matter. Fixed a timeline that within this time you will have to go back to your previous school. One school to another school he has come. Since the pay scale is falling down, the coordinate.
Very well. This will appear
with that. I'm giving this slip, my lord. I'm handing over this.
My lord, may I mention one matter? Contempt application, my lord. Inclusion in the daily list under the heading application. Last order in this matter, my lord, 8 August 2025. Kindly allow me to.
Contempt.
Yes, my lord.
Very well, contempt দিয়ে দিন একদিন আমরা ফিক্স করে নেব কন্টেম্ট আর অ্যাপ্লিকেশনের জন্য কারণ অনেকগুলো হয়ে গেছে করে করতে হবে
Grateful, my lord.
Thank you.
May it please your lordship, in this matter I am appealing for statement.
লিখে নিন none appears for the petitioner.
It was directed.
There is no order here in the records.
Anyway, so
Only
I
you
would
have
like-
the order with you.
No, the order I don't have,
Then
but I was directed to provide this
directed
information.
must be there in the order. Merely because you say I will not believe it, you have to have an order, or I'll have to say there is no direction. There is no direction granting you leave to file supplementary application. What is your case?
My lord, it is about the encroachment, my lord. Encroachment of the government land and causing impediment in my free and fair ingress and egress, my lord.
Encroachment on government land.
Yes,
Who
my
is
lord.
appearing for the government?
Affidavit
Private respondent who is appearing?
on advocate Munmun, someone on learned advocate Munmun says someone I have already.
Give me the affidavit of service. लिखे नहीं. Affidavit. Same thing.
There was an assault on the these things, advocate these things. Uh, 46 loss I am paying for short passover.
46, there was a direction on you to add the Zilla Parishad as a party and to serve.
Actually, I am not sure. For the clerk, I am paying short passover.
Passover করে দিন.
I beg to have the decision. We had there is some urgency. What happened, Lord?
But somebody
Well,
should be
just
there.
kindly hear. But this matter is pending before the Honorable Court. On the last two occasions, my lord, Mr. Sakko Sen, my lord, prayed for time. The matter was adjourned. He appears for the my lord, Murshidabad Jilla Parishad. Level proceeding under section 3 and section 4 of the West Bengal Land my lord, Eviction of Unauthorized Appointment Act had been initiated. And in the agreement itself, there is an arbitration clause. My lord, subsequently, my lord, termination of notice was running. I am running a diagnostic center, my lord, for the last 21 years on the basis of the lease executed by the Murshidabad Jilla Parishad. The lease was in the year 2004 for a period of 21 years. Now, my lord, what they have done, they have not terminated the lease agreement. My lord, I filed a suit. In the suit court, initially order of injunction was there. Ultimately, they filed an application under section 8 stating that arbitration clause is there, the suit is not met. However, my lord, trial court will not dismiss that section 8 application. Challenging that, they moved this honorable court. This honorable court said, yes, arbitration clause is there, entire matter referred to the arbitration. Well, subsequently, I filed an application under section 9 before the commercial court, Asansol. Commercial court will not pass an order of injunction restraining the parties, restraining the Jilla Parishad from dispossessing me. Now, in the meantime, this proceeding had been initiated. Now, what SDO is doing, SDO is saying that the order of the civil court is not binding on me. Like, kindly have a look at the way SDO is proceeding. Well, I have not seen such kind of order in my life. Kindly text note, I have just give me a leave to file the supplementary affidavit. I sub the supplementary affidavit. Kindly text note the order of the SDO once. It starts at page 4. Blood, may I just place it, blood? In pursuance to this office memo number such and such, dated such and such, the learned advocate Bikramji Datta on behalf of the ACA Healthcare Development Private Limited has appeared and filed Sajira, and additional deputy secretary Murshidabad Jilla Parishad also remains at present at the time of hearing. Additional ATS Murshidabad Jilla Parishad has stated the ACA.
My lord, sir, I am for the Murshidabad Jilla Parishad. Well, I'm led by Mr. Sakko Sen. But may I pray for a very short passover?
Let him come, man. May I just press.
I'll not pass any order until he comes. Let me hear him.
I'll inform him.
Yes. Now it says, my lord, Murshidabad Jilla Parishad has stated that Asia Healthcare Development Private Limited is in possession of the both plot numbers such and such. He added that in reference to the demand notice of annual lease of land, Murshidabad Jilla Parishad against 1.73 acres of land at Bahrampur Moja, plot number such and such, for setting up Rabindranath Thakur Diagnostic Medical Center, issued by the additional executive officer Murshidabad Jilla Parishad, communicated by memo number such and such. Asia Healthcare Development Private Limited paid some rupees 2,10,000 and odd through RTGS on 7/2/2022 to the account number such and such IDV of financial year 2022-23. In this respect, he has submitted the aforesaid communication a copy of the demand notice for such and such. Murshidabad communicated by memo number such and such. He also praised the field inquiry report on these two plots 960 and 915 may be sought from the BL and Bharanpur Sador block. It is mentioned that plot number point number 4 on the earlier order number such and such. Mr. Bikramji Datta, learned advocate, has stated that the opposite party also moved an application under section 9 of the Arbitration and Conciliation Act 1996, being the miscellaneous arbitration commercial number 11 of 2025 before the learned commercial court at Asansol, Paschim Bardhaman, an identity order of status quo regards possession has been granted on 28th of July 2025. On the last day, the case was fixed. On 25/9/2025, such an interim order has been extended till 15th of December 2025. He has also prayed that in any event, the administrative action initiated under the West Bengal Land Reforms, West Bengal Public Land Eviction of Unauthorized Occupant Act 1962 should not be override the judicial order dated 28th of July 2025, which is still subsisting. In support of which, he has submitted a copy of the order dated 25/9/2025, passed by the Land and Commercial Court on Asansol, Paschim Bardhaman. It is annexed as a part of the case. He also stated the opposite party has also filed an application before the Honorable High Court at Calcutta Commercial Division for appointment of arbitrator, white case number such and such. In the said matter, Asia Healthcare Development Private Limited versus Murshidabad Jilla Parishad. Murshidabad Jilla Parishad appeared in the said matter on 22/9/2025, when the matter was taken up for hearing. Learned senior advocate on behalf of the Murshidabad Jila Parishad submitted that they want to file affidavit. In this context, he has also submitted the order dated 22/9/2025 to the Honorable High Court at Calcutta in case number such and such. He also prayed the matter should be adjourned, particularly when the civil court's order is subsisting and the same dispute between the parties are being proceeded under the Arbitration and Conciliation Act 1996. The district magistrate on 4/9/2025 has addressed a letter dated 1/9/2025 of Hasibul Islam, learned advocate, High Court Calcutta, who has explained the following. Significantly, on August 22, 2025, when the matter was called, an adjournment was sought for by the learned advocate representing the petitioner, has sought for an adjournment, which was objected by the learned advocate representing the Jila Parishad on the ground, the citing the pendency of the caption petition. The petitioner is simply buying time and protracting the proceeding drawn under the 1962 Act. At this juncture, the Honorable High Court was pleased to make verbal observation. What prevents the authorities from proceeding with the so-called hearing, since till then, petitioners could not succeed in obtaining the formal order of injunction, restraining the authorities from proceeding with the so-called hearing. That apart, so far as status quo order dated 28 July 2025 passed by the first in miscellaneous case number before the commercial court at Asansol is concerned, the same is inter se and such does not affect the pending adjudication in terms of the proceeding so-called notice dated July 22, 2025 issued by the subdivisional magistrate, which apparently prior in time. More concerning is the fact that such order was obtained unscrupulously without disclosing the pendency of the proceedings under the Act of which was obtained, and this is nothing by playing fraud upon the court. In this background, humble opinion, there appears to be no impediment for the concerned authority to proceed with the hearing in terms of the proceeding so-called notice dated July 22, 2025. The district magistrate Murshidabad has thus instructed to proceed West Bengal Public Land Eviction of Unauthorized Occupant Act 1962 in compliance with the instruction of the district magistrate. The submission of learned advocate Bikramjit Dotto of the opposite party is not being considered, as the Honorable High Court has not passed any order of injunction or status quo in this regard. Now, Biller was directed to file an inquiry report. Now, Millard, kindly turn Millard page 5 of this order. Paragraph 4. Paragraph 4, Millard states that District Magistrate Murshidabad on 4/9/2025 has endorsed a letter dated 1/9/2025 of Hasibul Islam, learned advocate, High Court Calcutta, who has expressed the following. Now, Millard, kindly takes the order passed in this petition. Kindly see. But there must be a limit of making of submissions. I am saying all these things. Kindly see. He has stated on August 22, we prayed for an adjournment. And it is his case, we asked for an adjournment and we are delaying the matter so that proceedings cannot be proceeded. Can you see the orders passed by? First order is 1st of August 2025. Passed by Justice Biswajit Basu. Every service on record, as prayed, leave is granted. Now, as prayed for by Mr. Sen, learned senior advocate for respondent number 2 and 3 hearing. Hearing of the petition is adjourned. So, Millard, on the first day, Mr. Sen prayed for an adjournment. Come to the next order. That is our Millard 7/8/2025. 7/8/2025. I am just placing it. Mr. Sajan says, learned advocate for the petitioner file supplementary evidence in the petition. Let it be kept with the record. An accommodation is prayed on behalf of the Murshidabad Jila Parishad. The respondent number 2 and 3 hearing. Prayer is allowed. The matter is placed in the supplementary evidence. I have prayed adjournment. The adjournment was prayed by Mr. Sen on the last 2 occasions. And can you see the letter? Hasibul Islam letter.
It is August 22.
Yes, you show me the letter, August 22 order. You show place the order where this order was passed. I want to know. I want to see that order. And who is this Hasibul Islam? Who is this Hasibul Islam? How the magistrate, district magistrate is acting on his advice. Not only that, kindly consider. But DM.
Let us go into the matter.
Yes, I will go into the matter, but there must be a limit.
I am taking a mention.
I am also.
On the.
Let me place my case.
And my legislature will go.
Yes. Millard, kindly consider one thing. Today, Millard, your lordship note in the Jila Parishad, the Millard district magistrate is the administrative control of the Jila Parishad. Jila Parishad is. May I, Mr. Sir, please take your seat. Let me.
A show-cause notice is.
Yes.
I am saying that it is not maintainable.
Yeah, I will be saying it is maintainable 100%. As because I am covered by Wilpur judgment and other judgment, I will show that. Millard, my first point is this, Millard. In the agreement which was entered in the year 2004, in that agreement there is an arbitration clause. And District Magistrate Murshidabad was the named arbitrator in that arbitration agreement. And subsequently, there are several meetings are held. This is not in respect of running of a medical institution, medical center, diagnosis center. In those meetings, District Magistrate presided over those meetings. Now, there are several proceedings pending between the parties. Now, arbitration clause is there. I move Section 9 application. Order of injunction is there. I have annexed the order of injunction. The order of injunction is still subsisting. 15/12/2025 till 15/12/2025, the order of injunction is there. They appear there. Now, in the meantime, in order to frustrate my arbitration, I also filed Section 11 application. In Section 11 application, on the very first day, Mr. Sen also raised the immunity issue. Court directed to file an affidavit. He did not file the affidavit. Yesterday, he asked for extension, and it was extended. 9th is the date for final hearing of Section 11 application. Now, in such situation, what is their main object? Main object is to evict me anyhow, to take possession of the property in question. Now, the proceeding has been initiated by whom? By the SDO. The SDO is the collector in terms of Act 21B of the Act. Now, kindly see the situation. District Magistrate is the named arbitrator in the arbitration agreement. Order of injunction is there, not to dispossess me from the property in question. Now, SDO is acting on the advice of the District Magistrate, Murshidabad. I can press, Your Lordship, if Your Lordship sees the last order, the SDO is proceeding on the basis, as because District Magistrate directed me, so I cannot give any adjournment. So I will proceed with the matter. Now, can you see the Act? The Act says the District Magistrate is my appellate authority. In terms of Section 7 of the Act, District Magistrate is my appellate authority. Now, Your Lordship knows there are series of judgments. Now, if the person who is proceeding with the matter, unauthorized occupant matter, I must be an unauthorized occupant. My possession is being protected by the civil code. Can I be described as unauthorized occupant? Number 1 point. Second point is the person who is proceeding with the matter, he is acting on dictation. He is acting on dictation, whether he can proceed with the matter. He is not applying his independent mind. Kindly have a look. Once again, I am placing this order. Kindly see. He first of all, kindly see page 5. Page 5, last paragraph. It starts. In this background, in my humble opinion, there appears to be no impediment for the concerned authority to proceed with the hearing in terms of the proceeding comes so-called notice dated July 22, 2025. The District Magistrate Murshidabad thus has instructed to proceed to the West Bengal Public Land Eviction of Unauthorized Occupant Act 1962. In compliance with the instruction of the District Magistrate, the submissions of the landlord advocate, Mr. Bikram Singh Datto of the opposite party, is not being considered, as also the Honorable High Court has not passed any order of injunction or status quo in this regard. The High Court may not pass the order of injunction or status quo, but the civil court has passed an order of injunction or status quo. Can a quasi-judicial authority nullify the civil court order? But I am asking the question to myself. My first point, my lord, is this SDO cannot proceed with the matter, as because my lord, SDO has premeditated his mind. This so-cause is nothing but this is an outcome of the proceeding itself. My second point is this: I cannot be termed as an unauthorized occupant, as because my lord, my possession has been protected by a competent civil court. I have annexed the order in the first supplementary affidavit. I have annexed the order, and order of injunction is still in force. My third point is this: blood SDO is acting on dictation of the district magistrate, which he cannot do. My fourth point is this: the district magistrate is the appellate authority. So, beloved, appellate authority and trial authority cannot merge together and just to evict me. My fifth point is, beloved, this so-called notice was issued with a premeditation mind, so he should not be allowed to proceed with this case. Now, beloved, in this background, beloved, I just say, beloved, judicial authority passed an order, rightly, wrongly, whatever it may. He has participated in the proceedings, filed an application for vacating. The matter is pending before the commercial court. Now, my lord, next date is on 15th of December 2025. Now, my lord, can SDO say that, my lord, the order was obtained by committing fraud? Can, my lord, SDO say that I will not obey the order of the judicial authority? My lord, your lordship knows there is a judgment of Anita International. In that judgment, my lord, your lordship would find that Supreme Court says that the order passed by an authority is order as it is until and unless that order is set aside or modified or quashed by a superior authority. Otherwise, there will be an anarchy, my lord. Today, my lord, if order is passed against me, tomorrow somebody comes. So I was not a party in that proceedings, so this order is not binding on me. Even if I was a party in that proceedings, the order was obtained by committing fraud. So I will not obey that order. That is not the law. Law is otherwise. Kindly have a look, my lord. Kindly have a look, my lord. Just one judgment to that effect. I will just write. Well, can you text? Well, this is, my lord, Anita International.
Yes.
2016 9 SCC page 44. Now, my lord, your lordship, my lord, straightway comes to paragraph 54. Paragraph 54, my lord, page 100. Has also got it. May I just place it? we are also of the considered view as held by the court in the case of such and such. It is not open upon either to the parties to a lease or to any third parties to determine at their own that an order passed by a court is valid or void. A party to the lease or a third party who considers an order passed by a court as void or non-est must approach the court of competent jurisdiction to have the said order set aside on the ground as may be available in law. However, till an order passed by the competent authority is set aside, as was also held by this court in the case of such and such, the same would have the force of law, and any act or action carried in violation thereof would be set aside, would be liable to be set aside. Now, my lord, the order of injunction. Now, my lord, kindly have a look. May I just place 2-3 things from my writ petition itself? Then I will be coming. Now, my lord, if your lordship, my lord, straightway comes to page 36 first.
Page 36.
Page 36, my lord, this is the lease agreement. Now, my lord, then, my lord, your lordship, straightway comes page 44.
44.
My lord, kindly down, my lord, page 41 once. Page 41. I am 31. 41.
Yes.
Page 41, my lord, clause 14, 1-4.
Yes.
It says, my lord, there shall be a core committee comprising of the following members to advise on policy guideline, and their role shall be on advisory capacity. Now, my lord, B, the district magistrate member. So, in the core committee, my lord, your lordship would find district magistrate Murshidabad is a member of the core committee. There are other members. First one is the Savadipati, then last member of the parliament, then chairman of the Banampur municipality, additional executive magistrate, Karmadakko, chief medical officer of health, and 3 members nominated by the Savadipati Murshidabad Jila Parishad. So, this is the core committee, my lord, in respect of functioning of this medical institution. So, my lord, district magistrate is a party to this proceeding. He is an interested party. Now, my lord, kindly turn, my lord, page 44. Your lordship would find, my lord, I am just placing, that is clause 28.
Page,
Page 44, 44.
page 44.
Now, my lord, you will also find clause 28 says, in case of any dispute or difference arising between the parties herein or regarding validity and or interpretation of the agreement, the matter shall be referred to the arbitration of a sole arbitrator to the district magistrate Murshidabad. So, my lord, district magistrate has been named as a sole arbitrator. Next page, my lord, kindly turn, my lord. That is, my lord, page 51. Page 51, my lord, this is the minutes of the meeting. The meeting was held at the office of the my lord, Murshidabad Jila Parishad, such and such. Venue, my lord, date and time. Venue, you will also get it. The chamber of the district magistrate Murshidabad. Date is 29th of August 2018 at 3 p.m. You will also got it. To some extent eligible. Now, my lord, who were present in the meeting? The Sabadipati, district magistrate, Kormadokko, then my lord CMOH, additional executive officer, then other officers. Now, my lord, kindly see first line. District magistrate took the chair and presided over the meeting. Have you also got it? Now, my lord, the district magistrate took the chair and presided over the meeting. So, my lord, the district magistrate is the helm of affair of this Murshidabad Jila Parishad. He is controlling everything. Now, my lord, then, my lord, if your lordship, my lord, kindly turn, my lord, 2 pages I will be showing to your lordship. Now, my lord, if your lordship, my lord, kindly turn, my lord, page 57. Page 57, my lord. This is, my lord, the letter dated 11th of January 2022, issued by the, my lord, additional executive officer Murshidabad Jila Parishad regarding, my lord, termination of agreement dated 9th July 2004. Well, that means my agreement has been terminated. I am not going into details. My agreement has been terminated. My agreement has been terminated. Now, my lord, kindly turn, my lord, page 62. Next.
Yes.
Now, my lord, this is the letter dated, my lord, 28th of September 2022.
Yes.
May I just place this? This is a very vital document. This has reference to the caption letter issued by the unassigned, whereby your leasehold right over the Rabindranath Thakur Diagnostic and Medical Care Center granted under agreement dated July 9, 2004 and subsequent supplementary agreement dated March 3, 2005 was terminated following the breach of material contractual terms. Subsequently, we have received your communication dated January 12, 2022, whereunder you have requested to reconsideration of the said termination. Be it mentioned that you have committed the breach of material terms of contract, which has been duly communicated, delineated, and the said letter dated January 11, 2022. Moreover, we have also utterly failed and neglected to satisfy our queries concerning the compromise on quality of treatment and manipulation of the financial records. Thus, your said communication dated January 12, 2022 is devoid of any merit, as such does not warrant any consideration. The same was duly communicated to you on earlier occasions with a request to make arrangement for handing over khas vacant peaceful position of Rabindranath Thakur Diagnostic Center Medical Center to the Murshidabad Jila Parishad. Despite such request, you failed and neglected to hand over the peaceful position of the said nursing home and instead continue to transfer fund to our bank account on account of alleged rental obligations, notwithstanding the fact the contractual relations between the parties have ceased to have any effect in view of our termination letter. In this backdrop, you are requested to provide us with your bank account details, where we shall refund a sum of rupees 19 lakhs and odd, being the alleged payment received on and from 11th January 2022 to 28th of September 2022. You are further directed to make arrangement of vacate the premises, namely Rabindranath Thakur Diagnostic Medical Center, Care Center, and hand over khas peaceful possession thereof within a period of 30 days from the date of decision of the failure thereof. We shall be compelled to take initiate appropriate legal proceedings at your cost and peril, and you may please take note. This is the my lord. Now, my lord, then there I moved my lord civil court. Civil court, my lord, initially passed an order of injunction. The civil court order of injunction, you will also get it, my lord, at page 65. Page 65.
Page 65.
Yes. Well, this is my lord, order dated my lord, 10th of July 2024. Your lordship, my lord, kindly take the operative portion, page 66. Learned judge, my lord, narrated the facts. I am not going into all these facts. Page 66, it is saying the OPs being the defendant number 1 and 2 hereby restrained by an order of temporary injunction from taking any step to evict the plaintiff petitioners from the suit property without following the due process of law in any manner whatsoever. And they are also restrained from disturbing the peaceful possession of the plaintiff petitioners over the suit property until the next date. Then will not the consequential order. Now, my lord, this order was finally confirmed by the learned civil judge, my lord, at page 67. Well, in this order, my lord, what happened, my lord? There is a slight background. They filed an application under section 8 of the, my lord, Arbitration and Conciliation Act, citing that arbitration clause is there, so court cannot proceed. Learned judge, my lord, rejected section 8 application and confirmed my interim order, which was passed on 10th of July 2024. Well, the operating portion of the order, my lord, at page 71, your lordship would find that interim order of injunction granted earlier is made absolute for filing WS. Now, my lord, this order, that is on order dated 21st of March 2025, was challenged by the Murshidabad Jila Parishad by filing an appeal before this honorable court. Your lordship would get it, my lord, the order of the appeal court at page 72. My lord, order is dated, my lord, 15th July 2025, my lord, page 73.
Yes.
Well, till that day, I was protected. Well, I will be showing the section 4 notice, so-called notice, the date also. Kindly see the order, judgment on July 15, 2025. Now, well, kindly skip some pages, well, turn to page 85.
Page 85.
Yes. Page 85, paragraph number 31. It says, 31. The rest of the impugned order, the whereby injunction was granted by the court, was without jurisdiction, since the trial court in the first place was duty bound to refer the entire dispute to arbitration instead of itself entertaining the suit and deciding on the prayer for injunction made in connection with the therewith, and has to be set aside. Next, accordingly, FMA numbers such and such are allowed, thereby setting aside the order number 14 dated 21st of March 2025, passed by the Civil Judge Senior Division, First Court, at Bahrampur, Murshidabad, entitled suit number such and such, as a whole, referring the dispute raised in the said suit to arbitration. So, my lord, the matter has been referred to arbitration. I had, my lord, mistake I have committed, my lord, in while not presenting at the relevant time. Otherwise, I could have requested the court to name the arbitrator, so that the arbitrator could have been appointed on that day itself. That is, my lord, mistake I have committed, my lord. Now I am facing the consequences of that. Now, my lord, this judgment was delivered by the Honorable Division Bench on 15th of July 2025. Now, my lord, 15th of July 2025, judgment was delivered. Thereafter, my lord, on 28th of July, now prior to that, I, my lord, filed a section 9 application. Section 9 application, in section 9 application, you also would get the order passed in section 9 application in the supplementary affidavit, which I have filed, my lord, on the last occasion, my lord. It was affirmed on 4th of August. Supplementary affidavit. Page 4. Page 4, you will also get the order. That is order on 28th of July 2025.
Yes.
Now, my lord, your lordship will find this is an application under section 9 of the Arbitration and Conciliation Act has been filed with e-filing on 23rd of July 2025. Now, my lord, I am just keeping all these things. Can you turn my lord, last page? What is the order passed by the London court? After recording all the submissions, page 9 of the supplementary review. It says, my lord, accordingly, the parties are directed to maintain status quo regarding possession of the disputed property as described in paragraph 1 till the next date of hearing, which is fixed on 12/8/2025. The petitioner is directed to serve the copy. Now, my lord, order was till 12th of August 2025. Now, my lord, kindly take my lord, supplementary review which I have filed today.
Yes.
Now, my lord, your lordship, my lord, straightway comes to paragraph page 7.
Page 7.
Page 7.
Yes.
Now, my lord, your lordship will find order number 4 dated 25/9/2025. It says such and such. Kindly see last. Accordingly, for the ends of justice, the case is adjourned for this date. Interim order is extended till the next date. Next date is on 15/12/2025. So, my lord, I am enjoying the interim order passed by a competent civil court. Now, my lord, kindly take the repetition once.
Yes.
My lord, kindly take the repetition once, page 100. The notice which I am challenging. May I just place it, my lord? It is, my lord, order dated 22nd July 2025. May I just place it, my lord? Page 100, answer P13.
Page 100.
Yes, may I just place? The additional executive magistrate Murshidabad Jela Parishad has informed the district magistrate Murshidabad via memo number such and such dated 16/7/2025. But kindly consider, my lord, my appeal was disposed of on 15/7/2025. On the next day, 16/7/2025, that Rabindranath Tagore Diagnostic Medical Center beside NBST's depot Murshidabad, situated in plot number such and such, has been leased out by the Murshidabad Jela Parishad in favor of Asia Healthcare Development Private Limited, Charity International, second 12/4 such and such, and the sale lease was terminated by letter number dated 11th of January 2022 with the direction to vacate and peaceful possession of the nursing home within a period of 15 days from the date of issue of such notice. The additional executive magistrate Murshidabad Jela Parishad has placed a proposal before the district magistrate Murshidabad to take necessary action for eviction of the unauthorized occupant such and such from the premises of Rabindranath Tagore Medical Center by invoking the relevant section of the West Bengal Public Land Eviction of Unauthorized Occupant Act 1962. The matter is duly forwarded by the district magistrate Murshidabad to me for drawing necessary proceedings. Next, hence, since my considered opinion, the illegal encroachment are required to be removed and evicted from the public land for restoration of the lawful possession of plot number such and such. Being satisfied to that effect, I, Subdivisional Magistrate Bahrampur Sador, Murshidabad, being the collector as per provision of 21B of the West Bengal Public Land Eviction of Unauthorized Occupant Act 1962, as amended from time to time, in exercise the power vested in me under the provision of section 3(1) of the Act, do hereby treat the communication of the above mentioned herein above, the undersigned, as information received. I have copy. Text. Yes. Your lordship is looking at the provision of the Act. Your lordship can see, my lord, the section 2(1)B. 2(1)B says, my lord, that the collector means in Calcutta, land acquisition collector, Calcutta. Next, my lord, elsewhere.
Yes. Subdivisional.
Yes, subdivisional match. Now, my lord, kindly also take, my lord, section 7 also. Now, kindly take, my lord, section 2, subsection 8. That is, my lord, unauthorized occupation. What does it mean? Unauthorized occupation in relation to public land means the use of occupation of any person of the public law without authority in writing by on behalf of the owner thereof, and also includes the continuous use or occupations of any such land on the expiry or termination of such authority. Now, my lord, this is the meaning of unauthorized occupation. Now, my lord, kindly turn, my lord, section 7.
Section 7.
Section 7. Section 7, my lord, if you also can take section 7, it says appeal and review. An appeal from an order made under this act shall lie to A, the commissioner of the division where the order is made by the collector. Next, the collector where an order is made by an officer specifically appointed under subclause B of clause A of section 2. The collector is a district magistrate. It prepared within 15 days from the date of the order against which the decision of the commissioner collector, as the case may be, such and such and such.
Here the district magistrate itself is the collector.
Collector. Now, we'll kindly have a look, we'll once again, we'll page 100. Kindly come to page 100 once.
Yes.
Page 100, will not kindly see. Paragraph 3. Paragraph 3 says, hence, in my considered opinion, the illegal encroachment are required to be removed or evicted from the public land for restoration of possession of plot number such and such by the immediate owner, what remains to be decided. If not state officer or not the collector is so-called collector is of the opinion that I am of the opinion the illegal encroachment are required to be whether I am an illegal encroachment or encroacher or not, that is to be decided by him first. He is making his mind. Next, Lord, being satisfied to that effect, I subdivisional magistrate Bahrampur Sador, being the collector as per section such and such, as amended such and such, exercise the power vested in me and the provision of section 1 do hereby treat these communications as mentioned hereby, the undersigned as information received. Kindly see, next page is also important. As information received and take cognizance thereabout to treat it proper, to initiate the proceedings under the said act against the person, claiming possession, if any, on such encroachment and the public land as mentioned herabove, issue notice to so cause as to why he such and such shall not be treated as unauthorized occupant in the relation of the encroachment made in such and such and such and such. Now, will kindly see, it says upon the order why the encroachment such and such on public land should not be recovered, and within 15 days, 16 days from the date of issue of such proceedings come so cause notice not later than 782025 such and such. Now, my lord, it says to substantiate claim lawful possession, if any, over the public land with the material evidence. Let a copy of this proceeding come so cause be served. Now, additional district executive officer Mustafa Jela Parishad is requested to send the representative as well as the facts and circumstances to remain present at the time of hearing. This thereafter, this hearing was fixed on 882025. Now, this concern SDO, my lord, this concern SDO is basically proceeding on the advice of my lord District Magistrate Murshidabad. Now, my lord, so far as District Magistrate Murshidabad is concerned, my lord, I have shown to your lordship, my lord, that he is an interested party in these proceedings. Now, my lord, your lordship knows, my lord, there are judgments that if the authority, my lord, acted on dictation, then that authority should be debarred from acting. Now, my lord, to that effect, my lord, I am just citing one judgment, my lord. This is, my lord, 2013 7 SCC page 25. Now, my lord, it is, my lord, 2013 7 SCC page 25. I'll be just referring, my lord, 4 paragraphs. That is paragraph 36, 37, 38, and 39. My lord, first, my lord, I will refer paragraph 36, page 43.
Yes.
Yes, my lord. It says, paragraph 36 says, the statutory function is like the register, joint register of the cooperative societies functioning under the respective cooperative act must be above suspicion and function independently without external pressure. When an authority invested with the power purports to act on its own, or in substance the power is exercised by the external guidance or pressure, it would amount to non-exercise of power. Statutorily vested, large number of cases are coming up before this court and the High Court in the country, challenging the orders of supersession, and many of them are being passed by the statutory functionalities due to external influence, ignoring the fact that they are ousting a democratically elected board, consequence of which is of grave because of the members of the board of directors would also stand disqualified in the standing for succeeding election as well. Next, Lord. The register or joint register, while exercising the power of supersession, has to form an opinion, and the opinion must be based on some objective criteria, which has nexus with the final decision. A statutory authority will not.
I told my lord, a resolution has been passed now, but was our meeting.
Without hearing both the parties. কি আছে?
Participate in the court proceeding.
The problem is, we not on your lordship would be taking this matter on the next Thursday. In the meantime, 25th, will not SDO is
Since we are hearing it, postpone the
kindly will not
of that date.
25th kindly.
Lordship will keep it tomorrow, but let us.
Tomorrow I'll be taking specially assigned matters. What will be the harm if you take it the next week or immediately
that
after?
is not an harm, but then.
I'm not granting any stay. I'm asking you to postpone it.
My learned friend has not indicated. The hospital has become non-functional. I have given a lease of this Jila Parishad property to him for running the hospital. He has defaulted in payment of huge amount of license fee, committed fraud on that. I have taken a step under the lease deed for terminating his lease. And that is what thereafter that lease has been terminated.
Mr. Sen also
So he filed a suit for declaration.
file.
There, my lord, I went to the section 8 court. Then the appellate court specifically said that this kind of an injunction could not be passed.
Very well. The proceeding was initiated only in 2024, not before that.
No, not before that.
So 2022 was the termination. So till such time that I'm hearing it, since hearing has begun now, and it is on 25th, will it be proper for them to proceed with the writ also being continued to be heard?
We have raised a question of these all.
And he has raised a question of maintainability of the proceeding also. So that has to be thrashed out. Suppose they proceed.
But writ petition, all this is not there.
What?
Writ petition, this is not the ground.
Yes, these are the grounds. I can face it.
Writ petition,
He has not read the writ
the
petition itself.
ground which is there is the arbitration clause in the contract which supersede the.
No.
But he's saying that
All these things are treated in the writ petition. Mr. Sen perhaps has not read the writ petition.
Show me the ground.
Yes, kindly, sir. Can you done one paragraph, page 24. Page 24, paragraph 28. Your petitioner has also got it. Your petitioner states that respondent number 5 illegally assumed the jurisdiction and acted illegally on the dictation of the respondent number 4. That is the district magistrate. From the records, it will be evident that respondent number 4 is in fact controlling the Municipal Jila Parishad, and more so, he is in named arbitrator as per the lease agreement dated 9/7. Several meetings were conducted at the office of the respondent number 4. The respondent number 4, in fact, administering the Municipal Jila Parishad. Respondent number 4, in fact, issued necessary direction to the chief medical officer. So all these things are pleaded.
Kindly see, so the entire.
Well, then in that case, he placed the writ petition. Let it be heard out today itself.
Entire scheme of the act will be changed.
Well, you cannot
have to
adopt the
hear it today.
procedure.
Then we'll have to hear, because he is in difficulty. You are then in that case, if you are not allowing that leverage also of adjournment, if it has to be done on 25th only, then
Well,
that becomes a
I cannot stand in the way there, but then
if it is only a question of being adjourned and that also being opposed, then in that case it has to be. What is the way out? If the authorities cannot wait for one day for the writ court to function, the writ court will have to.
It's not a question of waiting for one day. Your lordship will see the notices of July.
Very
You-
good.
you took
So
our government.
2024 till 2025, till the time the writ petition was heard out, there was no urgency. Now, since I've started hearing on 25th, they will have to hear it. Now,
We are saying that.
no,
We are not
you
saying
being
that.
there, I did not expect this to come.
No,
At
no,
least
we are-
this should have come that, okay, we'll adjourn it to the next day. What is the harm? Instead of 25th, it is on 26th or 27th or in the next week. What is the problem? I'm not staying the proceeding.
Very
I'm
good.
only asking you to postpone it, and we do it quite often. Whenever the report is in season of the matter,
Since
we
your
do it.
lordship, I thought it can be heard tomorrow, but since your lordship is
No,
not.
tomorrow,
possibility,
because
other-
specially assigned matters, I have one day. Now, this is going to take some time. Tomorrow, again, the specially assigned matters, every day I'll be facing mentioning, because those matters are also waiting. There are a lot of motions there in specially
Lord,
assigned.
may I suggest one thing? Lord, considering the attitude of the SDO, Lord, your lordship will not pass an order of at least Lord, an injunction.
I'll say it to be postponed. To a
Kindly
date
pass
later
an order to
meeting.
that effect. Otherwise, Lord, again I'll be in deep trouble.
Lordship can say a short adjournment may be granted.
I'll
if
say
prayed for.
the proceeding may be postponed to a date later.
Well, I'm appealing on behalf of the writ petitioner. Well, this is my affidavit of service. Well,
I'm appealing for the respond number 11.
Sir, when did you make the representation?
this what's happened? The primary
Representation is dated July 15, 2025.
Yes.
You have filed a writ petition on 5th August. Is this not a premature writ?
prior to that, I have already served. Representation was made on behalf of the petition itself. And
When?
30th June 2025.
Very well.
My lord, during the pendency of the writ petition,
Huh.
The assistant engineer, executive engineer, Hooghly Highway Division has issued a letter
Huh.
to us. Therefore, it is found that the land is lying with the Hooghly Jilla Parishad. Therefore, the Hooghly Jilla Parishad may be incorporated as a party respondent, and kindly direction upon the leave to be granted
Very well.
Hooghly Jilla Parishad to
At them.
and serve the. Well, kindly see.
As prayed for by the learned advocate appearing for the petitioner, comma, we added as a party and the officer and the executive
Engineer WBSRDA,
WBSRDA
Hooghly Division, within bracket PIU,
দুটোকেই
হুগলি জেলা
পার্টি অ্যাড করতে হবে হুগলি জেলা পরিষদ as well as the executive engineer
WBSRDA,
WBSRDA
comma,
হুগলি জেলা
Hooghly
পরিষদ
Division,
হুগলি
within bracket
division, comma, হুগলি-
PIU,
ওই কপিটা দিয়ে দিন ওখান থেকে কপি
last second and third.
be added as parties to the writ petition full stop the petitioner shall serve copy
আপনি আসলে
But I am for the petition.
there was an inspection report to be filed is what I find from the last order
Yes, my lord, on last order, my lord,
there was a
Justice,
direction to conduct an inspection
by
and
the BLR.
and you were directed to pay costs for the
I have served copy of the order, but no cost has been assessed by the PLR, no notice has been served upon the petitioner. As such, petitioner did not pay any.
right who is appearing for the state
Man, I'm appealing for the state led by Nani GP, my lord.
madam there was a direction upon the BLLRO to
But I have not received any instruction.
My lord, my instruction is nothing has been, my lord, communicated to the petitioner for payment of cost.
let this inspection be conducted
Yes.
because this order has to be complied with
I'll give Rashid, I will give.
My lord, formal direction may be given
লিখে
upon
দিন।
I have come very fast because of that after giving the the representation.
Same order as.
This is the only one submission. Only kindly see the judgment because it is the obligation on that is the judgment of the my lord justice.
Obligation to do it on the next day.
No,
Then-
that is they will so much to take steps.
Very well.
So no mandatory order, I have an authority. So the same order which has been passed by your lord.
This writ petition. More expeditious than that, so you will not get that order.
So now, then
No, sir,
no,
don't
I am not
encourage this
paying for mandatory order. If I withdraw, suppose I withdraw, then I can again come before your lordship. So if your lordship permits me,
You file another representation, wait for 1 month, then come. Give them some time.
expeditiously, this is the law.
Very well. Only if they find that there is an encroachment, merely because
Ah,
you made
it-
a representation, if
so-
they go on acting on that, they will have to keep aside all their. duties
1
and
month,
pay
2
attention.
months, 3 months, whatever your lordship likes.
No use. I have passed my order. If you are.
No, I am not one there.
Very well. Then next matter.
The evidence of service be kept with.
Affidavit of service filed today be kept with the record.
Lordship, in this one, Sushant
Eh.
Pal is appearing for the state respondent and praying for all in alternate.
Taken from litigation, my lord. First round is there is a order passed by this honorable court directing
Very
the
well. Time is prayed for. Not today only. Next week again it will appear.
My lord, one indulgence, my lord, in item number 248, my lord, I have filed affidavit service, my lord, that has taken in record, my lord. Kind.
হ্যাঁ ওই affidavit of service 248 ফাইলে আছে তো নাহলে আবার রেকর্ড হয়ে যাবে ফাইলে থাকবে না ইউ গিভেন
Yes. Deeply.
if it is not in the file it will not go in the order
252 lawsuit, I am applying with the petitioner laws.
I am for the state.
Lawsuit, fact is that lawsuit, Honorable Justice Amritasena passed an order by directing the sub-divisional officer to initiate the appropriate proceeding against my client or anybody to evict the unauthorized occupant from the government if any. Sub-divisional officer started a proceeding. Initially started proceeding under section 10(3) of the West Bengal Highway Act, also section 3 of the West Bengal Unauthorized Occupants Act 1962 laws. Thereafter, initially inquiry was held. BLR submitted it. Initially, BLR submitted an inquiry report holding that the land is a Rayati land. Subsequently, after 1 month, another report was filed by the BLR saying that the property was government land by irrigation department. Sub-divisional officer passed an order of demolition by directing the irrigation department. I prefer an appeal, statutory appeal, lawsuit knows within time before the appellate authority. And also communicate the other respondent that I prefer the appeal. So during pendency of the appeal,
এই দিকেরটাও এরকম ব্লক করে দিন না হাফ তাহলে
respondent authority that I already prefer an appeal against the demolition order, statutory appeal. So not to take any steps till the disposal of the appeal. Even if the respondent issue a notice to the police authority to implement the said order, though the appeal was not heard till date. Challenging that notice, only praying that a statutory appeal provision is statutory right. I already prefer an appeal. So till not to take any action on the basis of the demolition.
Appeal by prefer an application for this order.
DM is the authority. I seen the appeal, only receiving the appeal. No number, nothing was given by the DM. So application cannot be.
Where the appeal is?
Lordship, appeal lordship, page 35 lordship. Page 35 lordship. Left hand side bottom portion only receiving seal chap 23rd September 2025. Page 35.
And when was the order passed?
Lordship, order was passed 2nd September 2025.
Page 33.
33 lordship. There are type
Digha Shankarpur Development Authority is the authority at whose instance the order was passed. Proceeding was initiated. Whose land it is? Digha Shankarpur.
no, the subdivision officer holding that the land of the land under the irrigation department, and also directed
Then why
the
have you made Digha Shankarpur Development Authority? in this
because of the order is saying that the road maintained by the Digha Development Authority, but land in the irrigation department. So the lordship, page 33 ordering portion 34, so that the irrigation directed the irrigation department to last portion, last paragraph lordship. Assistant Engineer Subdivision Officer Digha Irrigation and Subdivision is directed. Yes, then earlier lordship 34 second paragraph. Hence, all the enclosure program such and such is directed to remove their illegal construct within 15 days receiving this order.
You have made an application before the DM for stay.
No.
Appeal, lordship, page 35. Appeal was filed. Lordship.
Why are you not approaching the DM with an
Page
application? for
42
stay?
lordship. Page 42 lordship. Pair lordship. Appeal. Stay the operation of the impugned
File
order.
an appropriate application for stay. I am directing the DM to consider it and dispose it of.
Loss.
That will help because he's in the control. So
Loss.
instead of my taking cognizance of entirety of it and passing orders, I'm directing you within a week. You prefer file an application for stay.
But in the meantime, not to give
Well,
any
in
effect.
the meantime, what?
No, lordship. Lordship, later dated 46 lordship.
There is no such application for stay application. We only prefer an appeal under section 7 of the West Bengal Public Roads. There is no such application. Only prefer an appeal, and only one prayer is there, to
Stay there. Yes.
Otherwise,
That
we have
is
not.
there. The DM should have also considered it from September.
If
it
they
is
have
there.
filed an application, then you have
But
till
if-
today
no,
they have
the
not
appeal
filed
is
any.
there.
Appeal is there.
Appeal is
my lord.
there. So if
Appeal is
during
there, my lord.
pendency of the appeal, they are
Logically
they are
direct
removed.
to file an application for stay application within 7 days.
Yes. I have no difficulty. I file an application, appropriate application within 7 days. In the meantime, not to take any action in compliance of.
There is a police
the
report
law.
as well as the report filed by the subdivisional officer contact. অ্যাপিলটাকে ঠিক করে তারা ডিফেক্টিভ ঠিক করে নিতে দেখো অ্যাপিল করলে হয়তো ডিফেক্টিভ হয়ে আছে তাহলে তারা হবেই না কোনোদিন না না
It says eviction date has not been fixed as yet.
yes
This is the report of the police.
yes
Then
till
also
today
I
till today
granting
they
my
have
liberty
eviction
to
date
file
not
a
fixed.
appropriate application of the
Yes.
district magistrate and consider the same lawsuit
within 7 days
saving the time
approach
limit.
district magistrate
লিখে নিন the petitioner আপনার আঙুলটা ঠিক হয়েছে
My lord,
No, they have been directed to be added by order of court. What no?
only
Then
they are their land, but my lord, it's okay.
They are the authorized officer for the demolition.
no, I have seen there is an order of court, 4th of July, directing
My
you
lord,
to add them as parties, so you comply with the order.
My lord,
The petitioner shall serve 251, 252 কি হয়ে গেছে না? I understand, but what about this? There is a
Some call is there, not to it.
My lord, in appearance, item number 2, I am appearing on behalf of the respondent. We are seeking some time in this matter, my lord. We have already asked for the certain direction from the department. It will take certain time, my lord.
You want some more time?
Week's
How
time.
much? How much more
week's
time?
time? A week's time, maybe.
Week's
A
time.
week's time.
One more week. বসে লিখে নিন। Learned advocate appearing for the respondent CGST authorities prays for some more time. CGST now 1 and 2. Respondent numbers 1 and 2. CGST only. No?
Yes, actually, this is a service tax matter.
Very well. The respondent number, learned advocate appearing for the respondent number 2.
My lord, the appointment has been given from 1 to 3.
Respondent numbers 1 and 2 seeks an adjournment, full stop. Some more time is prayed for to take appropriate instructions, full stop. List this matter for further consideration on November 27th, 2025.
Grateful, your lordship. Grateful.
1 week. Next. Not today. Or call করে যান, not today করে দেন। না not today না করে 5 ওভার করবেন, নাহলে দুটোর সময় বসে কি করবে? দুটোর সময় not today করবে।
5, 6, 7, 8.
For the petition. It's 20, after 4 months is a 27 days delay only. I have explained. And the interesting order is that I know, I already informed Mr. Chakraborty. I'll do it on Monday. But SK Chakraborty says, in your lordship knows the judgment, says it is binding. And they relied upon a judgment of Bihar and see the officers. The next 8-9 is mine, my lord.
For the union, Mr. Kundalia appears for the union in 8.
8.
Want an order to be recorded?
As per you.
Not required.
Not today করে দিন।
8 and 9 my lord both.
Not today.
Nine, 10, 11.
11 my lord, for the petitioner. This is my service tax matter.
Other side not there. Not today.
11.
List 12. Other side not today.
Great.
My lord, Mr. Arnab Chakraborty is appearing in this matter, my lord. He's indisposed, my lord. My lord, may kindly keep it next week, my lord.
Not today means next week, because tomorrow will be
My lord.
specially assigned.
Great.
17 both already your lordship passed for the similar 16 and 17. They did on Monday.
Not today. Similar order means which order?
This is one of the NC print. That day I pointed out the similar orders, one of the other for different tax periods, same the petitioner. This one 10%.
10%. Okay. Well, next. You bring a copy of that order, so that will be easier. Chalo.
My lord, I am for the petitioner for 20, my lord.
Okay, not today.
My lord, only one request, my lord. I'll be traveling on 24th.
So,
Audit-
so you want when?
My lord, either on 25th or 27th, either of the dates, my lord, pleases.
Okay. 20th একটা order record করে দিন 20 as prayed for by the learned advocate for the petitioner, list this matter on November 27, 2020.
Grateful, my lord, grateful.
হোক না 27 এ তো এটা তো গ্রুপ 4 এর ম্যাটার আসবে অসুবিধা কি
Obliged, my lord.
not today not today 22 not today 23 পাঁচটা বার করে রাখুন 23
29 also I am for the petitioner. It's not a huge delay. So, my lord, I took instruction about the matter that I took for the cost, my lord. I already take instruction. My lord, I leave for my worship.
not today এমনি কল করে যান যদি কেউ থাকে হবে নালে আবার উঠে যাবে কিছু করার very good not today don't make any prayer it is already going to be not today no need to make a prayer on this 41 বসে যান না বসে কল করুন দাঁড়িয়ে আর কল করার দরকার নেই তো হ্যাঁ আরামসে কল করুন দিদি এরকম বাঞ্চে কল করে দিন 50 to 60 এনিবডি এরকম লিস্টে দেখিয়ে দিন যদি থাকে তাহলে বলবেন নাহলে ফালতু সব কল করবেন 400 মিনিট লাভ নেই ঠিক আছে কাল কল করতে বসে কল করুন
41, I am for the petition, no?
ভেরি ওয়েল 43 হয়ে গেছে, তারপর তো আনঅথরাইজ দরকার নেই আর। দরকার নেই, ছেড়ে দিন, কেউ আসবে না।
May I, okay, may I submit the affidavit of service?
In which matter?
241?
You can say you want to submit, but the other side is not there.
Yeah, other side is not here.
You want an order to that effect?
You can keep it for records.
No,
Okay.
that you do it on the next day when your other side is also
Okay,
there. It won't
thank you, ma'am.
serve and it
Thank
won't
you.
help you. Won't serve any purpose.
Okay. Thank you, my lord.
এটা রয়ে গেছে একটা অ্যাফিডেভিট অফ সার্ভিস। কেউ এসে যদি মেনশন টেনশন করে তাহলে ডেকে নেবেন, চলে আসবেন।
Item number 1.
Malad, I appear on behalf of the petitioner.
Not today. Not today.
Item number 2.
Not today.
Item number 3.
Same.
Item number 4.
Same.
Item number 5.
Not today.
Item number 6.
Not today.
7.
My lord, I'm
Not
the
today.
petitioner, my lord, Mr. Farooq Rajak, in this matter, my lord. I'm praying to accommodate it in the next week. Please,
Not
just
today means next week, Monday.
Monday.
It will be Monday only. Yes.
Item number 8.
Not today.
9.
Not today.
10.
সব not today করে দেবেন কেউ না থাকলে
11.
12.
12.
Lords, I appear for the petitioner in item number 12 and 13. May I request that this matter may be taken up tomorrow?
I spoken other side of said okay.
Just that I've come from outside. If it is at all convenient, then
I'll try. Tomorrow we have a different determination.
right.
We take specially assigned matters tomorrow.
Right.
So many buttons is appearing. I spoken just now. He said if court allows, I can.
ঠিক আছে কালকে এটা থাকবে মোশন গুলো থাকবে তারপরে অ্যাসাইন ম্যাটার্স ধরবে কারণ অ্যাসাইনডে তো আমাদের মোশন আছে কি নাকি শুধু হিয়ারিংই আছে What is this? There is some urgency here, or it can wait till Monday.
No, my lords, no urgency in the sense that we can, my lord, then in that case, instead of Monday, I have some difficulty, or could it be on Wednesday then?
It can be. Only thing is that you'll have to go and come back. That is the problem.
Yes,
no?
my lord. That I'll have to do in any case. Even if it is on Monday, I'll have to go and come back.
No, no. Tomorrow, if it is tomorrow, you don't have to go back.
Tomorrow, I don't have to go back. Then I'll stay back. If it is at all convenient.
What to do? কালকে রেখে দিন দুটো ম্যাটার এই দুটো লিস্টে দিয়ে দেবেন যে এই দুটো ম্যাটার কালকে নেওয়া হবে What is the matter actually?
Yes, my lord. So there are two matters. One is for a refund which I have not received. Some 125 crores of refund despite regular follow-ups, despite so many orders passed by the tribunal, etc. I'm just not getting that refund. So one is that matter, and my lord, now we are in need of some funds. So this matter had come up prior to the vacations. At that time, the honorable bench told me that you take it up after, but now that you come, there's some urgency in the matter. I can't say it is a matter of life and death, but those funds are required. That is one. And the other one is on reopening, where my lords really, whenever my lord may keep it, I don't have a stay in that. My lords, prior, again, it came up earlier. I had mentioned that there is one additional ground which I wanted to take. So the honorable court put to me that that additional ground may be filed by way of a supplementary affidavit, and thereafter you may press for your interim relief. So in that I need interim relief. That's my immediate urgency, because I've filed my return. He's likely to start the assessment proceedings. If the proceedings start, then again I may have some difficulty.
But tomorrow also I don't think there is certainty. If something of this kind continues tomorrow, then what will happen? Because
I don't know, my lord. I have not ready.
That is why instead of keeping it tomorrow, we should keep it next week. That will be safer.
Very well. Next week, what else? I appreciate it. So in that event, if I may request that the matter may be taken up on Wednesday or Thursday?
Wednesday.
Wednesday. That's
Wednesday,
26th.
Thursday, any day. Thursday. Let's have it on Thursday then.
Thursday the 27th, maybe.
Thursday, because priority it was Thursday আসছে Thursday আরো কিছু আছে নাকি এর আগে আছে একটা কাজ করুন
On Thursday, this page also may sit next Thursday if it is not taken up, or it is better to penalty.
Yes, that to every Thursday it will have.
It's better to
Yes, then my lords. If
Keep it on
Wednesday is a clearer day, then perhaps.
Wednesday কিছু আছে নাকি একটা কাজ করুন ওই কালকে এর নিচে ডেট দিয়ে দিন এই দুটো ম্যাটারের নিচে ডেট দিয়ে দিন আর এখানে নোটে দিয়ে দিন and date fixed matters কালকের জন্য today the matters with date fixed for today and especially assigned matters will be taken up এইভাবে ডেট তাহলে কালকে নিয়ে
tomorrow.
We'll take it tomorrow.
Two. Deeply obliged, deeply.
I will inform you, Mr. Bhattacharya.
Grateful.
যেরকম থাকে হ্যাঁ তো যেরকম থাকে সেরকম থাকবে তাই থাকবে হয়তো ডেট টাইম ফিক্স করে দেবো 3টে
Item number 40. Item number 15. 16. 17. 18. 19. 20. 21. The respond. 22. 23. 24. 25. Code application. Item number 26. 27. 28. Item number
Yes, sir. Your Lordship, I appear in item number 28.
Yes, ma'am.
Your Lordship, the main counsel was arguing he's requested to fix a date and time so that he can appear physically before the court.
Your other side is not there. When do you want?
Your Lordship, anytime next week will also be fine.
It is there in the list. It will be called on again next week.
Your Lordship, since it doesn't come a lot of times, like it's been consistently listed and it doesn't come up, and the council isn't.
It may reach. It's a for orders matters. Let us see.
Your Lordship, actually, we appear from the main council is from Delhi, so he has to travel and time may be fixed.
Very well. So in the absence of your other side, I cannot fix a date. Your other side is not here.
Your Lordship will inform them if that would be okay. We'll inform them over email.
Your other side should be there. I'll fix a date in their presence.
Okay, so Your Lordship, if you may extend the interim order until the next date. There's a stay order in this matter.
Is it going to expire today?
Your Lordship, it was until the matter was next taken up. So today, since the matter is taken up, if you could
unless an order is passed today, it will not be taken up. I'm just making it not today. It will be just adjourned without any order. As good as not being taken up.
Much
Yes.
obliged, Your Lordship.
Hearing number 30, 31, 32, 33, 34, 35, 36, 37, 39, 40, 41, 42, 43, 48, unauthorized documents. Item number 44, for hearing group 2. Item number 45, for hearing group 4. Item number 46, 47, 48, 49, 50, 51, 52, 53, 54, 55, 56, 57, 58, 59, 60, 61, 62, 63, 64, 65, 66, 67, 68, 69, 70, 71, 72, 73, 74, 75.
ছেড়ে দিন, উঠে যান। একবার চলে আসবেন, নালে কালকে একটা কাজ করব। টুডে কোর্ট অ্যাপ্লিকেশনস উইল বি কল্ড অন বলে লিখে দিন, সবকটাই কল্ড হয়ে যাবে। তাহলে এক্সেপশন আমরা করব না, কালকের জন্য করে দিই। কারণ স্পেশালি অ্যাসাইন তো আমাদের হিয়ারিং আছে, শুধু মোশন গুলো তো ধরা হচ্ছে না। টুডে লিস্ট উইল বি কল্ড অন সিরিয়ালি, লিখে দেন। হ্যাঁ, না, taking
My
up group
lords,
4, I'll be taking up group 4 matters tomorrow also. So it will be at the same position where it is today. If it is taken up, it is taken up. If it is not taken up, not taken. So I'm not going to make an exception. That will be better for all.
Yes.
Yes, madam.
my lords, I was just asking that only. My lords has already addressed that point. I was being led by Mr. Khaitan. He has made substantial arguments in the matter OD 17, my lords. So, my lords have already said that it will retain its position for
Yes,
tomorrow.
yes.
Yeah. Much obliged, my
Because
lords.
motions could not be taken up, so I think that on Friday, instead of going for hearing matters, these motions may be touched.
Yes.
এরকম করুন। যা হবে হবে, কোনো অসুবিধা নেই, ইউজুয়াল কোর্সে আমরা যাচ্ছি। থ্যাংক ইউ।
Much obliged.